to marry down the road. It's not enough that a will is imbalanced, that one child perhaps gets almost everything and the other children get less. That is not undue influence. You have to have actual positive evidence of coercion. So if you are a beneficiary or a beneficiary who, or somebody who feels should have benefited under the will, you are going to have actual evidence of undue influence. A suspicion in and of itself is really not good enough. I mean, I think you'd rarely see a claim of undue influence run on its own on that basis, because it's just very difficult to bring home. It's often tagged on to something else, sort of as a by the by. We think there might be undue influence as well, but we're not betting everything on it. And so that's something that's very important to remember. And I think from a client perspective, they always think that this is something that's going to sort of bring it all home for them, and that's just simply not the case. The next, signpost on our road is legal right share, and who is entitled to a legal right share. And as you know, the spouse is entitled to elect to take a legal right share of half if no children and a third if there are children. What we have, again, more recently, a sort of a new amendment or someone else to consider, is that of the civil partner. And the civil partner equally has a right to elect to a legal right share. But the civil partner's legal right share is actually somewhat different to a spouse's legal right share, because in certain circumstances, the civil partner's legal right share can actually lose its priority if there is, for example, a child who has a successful 117 claim. So there is a difference between being a civil partner and being a spouse. For the purposes of the legal right share, it's somewhat unique, I suppose, to the civil partner. If you're a spouse, you have legal priority within the estate, but if you are a civil partner, you do so but subject to any potential 117 claim. As I'm sure you're aware, obviously a spouse or a civil partner has to elect to take their legal right share, and of course they may not choose to do so. Just a decision then in the Supreme Court in relation to the legal right share and the nature of the right. It is actually a right that vests automatically, so the spouse or the civil partner doesn't actually have to do anything to, I suppose, have the right kick in. It exists automatically, so the notice must be served, and if the notice isn't served, obviously the spouse is still entitled to their election. So obviously the whole realm of civil partners is sort of a new area that we have to contend with, but equally cohabitants. So my paper goes into a bit of detail on cohabitants and the nature and extent of their rights, and obviously the relevant act is the Civil Partnership and Certain Rights and Obligations of Cohabitants, Act 2010. And Section 194 is the relevant provision in respect of challenging a will. So it's not obviously the same. A cohabitant doesn't have a right to a legal right share, but what they can do under Section 194 is apply for provision out of the estate by virtue of their position as a cohabitant. So as you can see here, the three parts, I suppose, to the application. You've asked for provision out of the estate, provision has not been made, or no adequate provision has been made, and by virtue of the rules of intestacy, the cohabitant has not benefited from the estate of the deceased. That's in a position where there is no will, obviously. So what then is a qualifying cohabitant? It's basically two people who have lived together, I suppose, in an intimate relationship for a period of 5 years if there are no children, and 2 years if there are children. In determining, I suppose, the nature of an intimate relationship, these are the factors that the Act sets out as to be considered in determining, as I said, whether or not you are qualifying cohabitants, and that's the length of the relationship, the basis on which the couple live together, their financial dependence and, I suppose, financial interdependence, the financial arrangements as between them, whether there are, I suppose, children, and whether, you know, there is cross support, I suppose, of children, how they present themselves in society is also a further factor. So these are the considerations again. So I suppose in your client scenario, couple who are perhaps unmarried, living together, these are the relevant factors. And obviously it's going to, well, not obviously, but I suppose naturally it tends to be older couples who this is going to be of relevance to, and whether or not they are cohabitants. I suppose equally it's quite likely that older couples are perhaps maybe less likely to actually get married, and they do have this nature or this kind of a relationship. What then is a provision? You know, how is that to be determined? And again, there's more guidance in the Act as to the extent to which, you know, you are entitled, I suppose, to be provided for as a cohabitant. So my paper discusses just a really interesting High Court case of DC and DR, which is a decision of Justice Baker. And this really is the first, as far as I'm aware, big case on cohabitants, and certainly a significant case on the right of a cohabitant provision out of an estate. And in this instance it was DR, even though he appears as a respondent in the application, who was making the application for provision out of the estate under section 196. And DR, I think, was a man perhaps in his early 60s. They'd been in a relationship for over 15 years. He'd been in a relationship with the deceased. They lived in the same house. They socialised obviously together. They presented themselves at family functions together. Obviously it was his position that they were in a relationship. The deceased had inherited a large sum of money, and she had actually paid for all of their sort of luxuries, we'll say, their gym membership, all of their restaurants. He lived in her old family home. He didn't have any accommodation of his own, and he'd actually had his own family farm, or his brother was farming, and he'd left that and come to live with the deceased. And it was the deceased's brothers who were challenging DR's rights to any provision out of her estate. The deceased had died intestate, and so he brought this application because obviously he had no other rights. And one of the bones of contention, which is actually very interesting, in that the brothers objected to the very fact that Dior was in a relationship with the deceased. So even though they were living together, the brothers' argument that it was more in a companionship or a friendly sort of manner and not in an intimate way. And Judge Baker was ultimately satisfied on the evidence that their relationship had been intimate. And it was interesting, she said that while it's important that perhaps their relationship may be sexual to begin with, it doesn't have to continue to be so, and that wasn't a relevant factor. They were clearly a couple, they presented themselves as such, and she was satisfied that they were cohabitees for the purposes of the Act, and that Dior was a qualifying cohabitant. So then she went on to consider, well then what sort of provision should we look to make for Dior? And although the deceased had died without a will, she had left a letter which had kind of outlined her intentions, which was broadly that the family home she lived in was to go to their brothers, but that other property she had and other income was to go to Dior because Dior had no home of his own. And so ultimately the judge broadly ordered, in line with that sort of letter of intent, I suppose, for want of a better term, because it was, gave an indication of what the deceased really wanted. And ultimately the judge gave, I think it was approximately 45% of the estate to Dior, because she was satisfied that they were cohabitants, obviously, but more so that they really truly had a relationship of financial interdependence as between each other. He was certainly relying on the deceased in terms of she provided all the comforts, I suppose, in the relationship. She bought them both new cars, for example. She paid for holidays and things like that. I mean, she was financially better off than he was, and she carried the the financial side of the relationship. And what's interesting about this, it's just a very interesting case to read from sort of a human perspective, if nothing else, because Dior, I think, certainly a man in his early 60s, seemed to be from a farming background. I think it seemed to be maybe a Munster case. I wasn't 100% sure whereabouts it was, but Dior clearly did not want to be bringing this application, was very reluctant to do so, but fundamentally he had no home and he didn't have the means to buy a home because he had been in this relationship whereby he had been supported, and so it was for this reason I think the court very much felt for Dior. So the Act does state, though, Section 194 of the Act does say that the provision to be given to a cohabitant is to be restricted by the amount that he or she would have received had they been married. So basically what that says is that it should be somewhat analogous to the legal right share if there's a will. But obviously there was no will in this instance. It was an intestate situation. If they'd been married, he would have obviously been entitled to everything. So that is a factor that the court took into account, but again, as I said, awarded approximately 45%. But Judge Baker was very keen to say that, this isn't the marker, this isn't the rule, it's not 45% for everyone. In this particular scenario, I think that letter of intent by the deceased, whereby she indicated what she wanted to do with her estate, was held to be determinative. So this is another challenge to a will that I think clients are often very attached to, and just I've highlighted in red the core of Section 117, so that the testator, and the first thing, which it's just sometimes it can slip your mind, but obviously 117 can only apply in a situation where there is a will. If it's an intestate situation, obviously 117 has no application. So the testator must have failed in his moral duty to make proper provision in accordance with his means. And the test, I suppose, or the objective, the test to be applied by the court is the point of view of a prudent and just parent who has to take into account the position of other children and also any other circumstances which may be relevant. So, as I said, 117 is something that it seems to me, from my perspective, that clients get quite hung up about, and I'm assuming that it's something that, in first consultations might come up, and it's actually very difficult to bring a 117 application home. It's, that you didn't get as much as your siblings under the will isn't really, or at all usually, a good enough reason to bring a 117 claim. It has to be, or it tends to be, quite a stark differential. And moreover than not, it's particularly vulnerable applicant. So it is somebody who needed perhaps extra support from their parent that they didn't receive maybe through their lifetime, or did receive through their lifetime to the extent that they became dependent on that support. That support is now being withdrawn, and they need the support again, or they need the support into the future. Just in my paper there, I have I suppose the first important or relevant case, or a quote from Judge Kenny in a decision of FM and TAM, and that sets out the test that a court will apply. And that's that at the time of death is what's relevant. So you have to look at the time of death, you have to look at the testator's means, you have to look at all of the circumstances around the testator, who is the testator responsible for, and that doesn't even necessarily mean children, it can be elderly parents. Obviously there are all manner of financial dynamics that can apply. The second quote that I have there in my paper from a Supreme Court case in a state of IAC, that just says the court can't rewrite the will. Just because you would have written the will differently, or you might have given all 5 children an equal amount, that doesn't mean that a court is entitled to do that under Section 117. And again, 117 has to be balanced with the freedom of testamentary disposition. A testator, they want to give nothing to their children, should be permitted to do so. And all 117 says is that they should be permitted to do so unless they have perhaps a dependent, or as I said, somebody who's vulnerable and maybe needs additional support, or they have somebody who they gave no provision to in the course of their life. So it's very often, for example, it might arise in a situation whereby you have a child who was raised by a single mum, for example, and dad was never at all involved, never gave any support, and in those circumstances a 117 application may be appropriate. My most recent 117 consultation concerned a family who were very upset that their dad's new girlfriend got more than they did in the will. Now they were still provided for under the will, but perhaps the new girlfriend got a bit more. And that's a very difficult position to be in. They had also been provided for in the course of their life, not extremely generously, but certainly sufficiently provided for. They've been educated and given some small sums of money. A claim like that, which often arises because there's this unique family dynamic and second partners and whatnot, that still, that rarely marries with the Section 117 claim. And there's often a whole other agenda behind, obviously, the beneficiaries bringing the claim in that instance. So it can be fraught for us, unfortunately. But Judge Kearns, as he is straight talking, really gave the best set of criteria, or often, you just want these things in plain English, and that's what this judgment does in the estate of ABC. And he literally, and I have them listed in my list, and just a summary of them here, but they go from A to R at pages 8 to 10, and that is literally a checklist of a 117 application. And he began by saying, well, look, there is a social policy reason behind a Section 117 application. There are certain people with vulnerabilities, or certain people who require additional support, who may have, as I said, received that support from their parent, and then the parent dies and it's cut off, or didn't receive it in the course of their lifetime. So there is a reason for 117, it has a place, it is relevant, and obviously should be used when required. He stated that there was a very high onus of proof, and that really is the difficulty, I think, with the 117 application. It's not something that can be taken, just because you didn't do as well as your siblings under a will. It's just significantly more of that. And it's the fact that, I suppose, the unique position of a parent to a child and their relationship, but you cannot look at that relationship in isolation, because very often there are other children with other needs. And he outlined that there obviously are special circumstances, and this is another, I suppose, common or more common example, is somebody who has worked on a farm their entire lives, with the hope and expectation, and we'll talk about estoppel in a minute, but the hope, I suppose, of the farm ultimately coming to them, or working an entire lifetime for less than minimum wage, again on the hope or expectation on death that they would receive the farm. And this is often, that sort of a claim is often brought in tandem with an estoppel claim. And I think, which is interesting, and I suppose just reflective, I suppose, of Judge Kearns, he's quite a strong character. And he's correct, though, that parents must be presumed to know their children better than anybody else. So when a testator sits down to write a will, there has to be that presumption there that this is a deliberate decision. Now, we all know that sometimes, or very often, testators like to leave political statements almost in their wills and tell everybody how they really feel by way of their last will and testament. But as long as you've got capacity and you are deciding not to give Johnny any of your estate and you just want to distribute between your 4 children, well, you should be entitled to do so. And again, the courts must be happy that the parent did so in the full knowledge that they know Johnny and maybe they don't give the money to Johnny. So that's, I suppose, at the core of 117. I'm not going to go through all of those points, but it is very interesting. And so the other thing he did say, sorry, that is of relevance, which I don't have up on my slide, is that you do, of course, have to look at the financial provision made for a child in the course of the testator's own lifetime. And very often, and I think this is probably fair, if a parent has provided a child with an education, perhaps sent them to college, perhaps set them up on their first, I don't know, their first job or whatever, help them, then, you know, there's a sense of, well, that's probably enough. You know, how much more are you required to give? And that shouldn't be relative to the financial means of the testator. The testator is a billionaire. It shouldn't really matter that he didn't do more for you than perhaps educate you and set you up in life. You know, parents do not have ongoing obligations to their children. Which the final point about 117 then as well is that it doesn't apply to grandchildren. It only applies to children. So then, as I mentioned, sort of in the context of a farmer, claim in estoppel can also arise. So this is, and the farmer is the best example, you know, the son who worked the farm his entire life, never went anywhere, never did anything, was entirely dedicated, probably earned, as I said, less than the minimum wage, always in the hope and expectation that he was going to get the farm, and then doesn't get the farm in debt. So the claim in estoppel will arise where somebody has acted to their detriment on an expectation or a belief that something will happen, something positive, and that they're encouraged to do so. They're encouraged to act to their detriment, and I suppose they're encouraged that there will be, I mean, it's often, or it's usually not even actually orally expressed, but there is that encouragement there. Oh, sure, you're great, and you know, maybe one day this will be yours, that kind of thing. So a claim of estoppel often exists. You know the scenario, particularly rural Ireland farm scenario, whereby the neighbour down the road is helping or the nephew is helping. This is where estoppel comes in. Okay, moving then to the limitation periods, and these are set out in more detail in my notes. Really, I suppose the most important thing in your head should probably be 6 months, because a few of these, the clock begin to run at 6 months from when representation is first granted. So section 117 is 6 months from representation. Also, the application under the Cohabitants Act is 6 months. The election for the legal right share is 6 months on the receipt of the notification, or 1 year from the date of the grant, whichever is later. Section 126 of the Succession Act says 6 years in respect of a claim on an estate. So, for example, if you are a wife and you've elected to take your legal right share, so we say that you were left nothing in the will, just as an example, and you elected to take your legal right share, there was children, so you were getting a third, but nobody's given you the third yet. After 6 years, you're entitled to bring an application to enforce your claim. In terms of promissory estoppel, time begins to run for the purposes of promissory estoppel when the estoppel has accrued, so when you have all the necessary elements of the estoppel. So obviously you'll have probably already acted to your detriment years ago in the hope or the encouragement that you would get the farm years ago, but of course you don't realise you're not getting the farm until, we'll say, the date of death, when, well, the will is effective and the will doesn't make any provision for you. So that would be the most likely time that promissory estoppel will arise. In terms of obviously claims existing at the date of death, the time limit is 2 years, or the usual period of limitations, whichever first expires. So the final signpost on my paper is costs, which is obviously quite important from the perspective, in particular, I suppose, of the solicitor who is carrying the contentious proceedings. And as a general rule in a contentious probate matter, as long as a case is stateable, and not frivolous or vexatious, the costs will be the costs from the estate, so they will be covered. And Elliott and Stamp, I suppose, really is one of the seminal cases in that area, whereby there was a beneficiary challenged the testamentary capacity of the testator, and also asserted that that there was undue influence. So she withdrew her claim in relation to testamentary capacity and proceeded on undue influence only. And she was actually only awarded, she was unsuccessful, but she was only awarded a third of her costs, and that was appealed to the Supreme Court. And her argument was, this was a genuine case to be made, and I would like all of my costs, obviously. But the court said, these are the two questions, obviously, the test really, I suppose. Was there a reasonable ground for litigation, and was it conducted bona fide? And one of the difficulties that arose in Elliott and Stamp, I suppose, for the plaintiff, was that she had been provided with all of the necessary information before she instituted proceedings that should have shown her that there was no undue influence. And so what the Supreme Court was really saying is that you had all of the information before you brought these proceedings, and you did so anyway, and you shouldn't have done so, because therefore you're not getting all of your costs. And I suppose what that means from our perspective is that you really do need to agitate all of that information that you receive before you recommend bringing contentious probate litigation. There really does need to be a genuine need for litigation. If you are being provided with all of the information, say from a testamentary capacity perspective, you've been provided with lots of medical evidence. From an undue influence perspective, there's no evidence, or you have no evidence yourself of any undue influence, or the client doesn't, and equally, there's no suggestion anywhere else that any undue influence was exercised. Perhaps, what would the best way, I suppose, say if you had a particular person, Mary, down the road was exercising undue influence, even say you were given a statement from Mary and she said, well, I never undue influenced, and I was surprised as anybody that the testator left all this money to me. If you are receiving that kind of documentation from the solicitor on the other side, well then you really do need to consider whether or not there is a bona fide need to bring this application. And obviously as well, the court will consider the manner in which the litigation was brought, or was it conducted bona fide. If it's just purely malicious, which unfortunately can happen in the sphere, that equally is something that a court will take into account. So it's not a given in contentious probate litigation. If it's bona fide, and if there's a genuine need to bring the litigation, genuine issue between the parties, well then it's most likely costs will come out of the estate. And it's Vella and Morelli, which is the decision which really established that fact that you are entitled to your costs from the estate. And the public policy reasoning for that is that, often, at the time, it was in the 60s, emphasis was placed, and maybe it's still true, on sort of the Irish obsession with property and owning property and knowing who owns what property, and that often, obviously, the most frequent way in which property is transferred is by way of a will, and therefore there is a societal need to actually figure out who owns property, and basically to figure out disputes in a will or issues in a will. And so from a public policy perspective, because we want to ensure that the correct ownership of property, well then we should allow people to bring this kind of litigation without fear that they will be penalised for costs, where there really is a genuine concern as to the interpretation of a will, for example, or who the correct beneficiaries are. The test, I suppose, in relation to costs in administrative actions, so obviously actions brought, say, by the executors, usually to resolve a question, just the test to be applied there is obviously somewhat different to that in a contentious application, and the test in that instance is really, I suppose in the first instance, if the executors have a genuine question that they want to ask the court, which can often arise that even with solicitors and counsel involved, they don't quite know the answer, and in those circumstances, again, as long as it's genuine, costs will be allowed. if the beneficiaries are perhaps unhappy with how the executors are interpreting a will, and there's an alternative way in which the will can be interpreted, that too will be seen as a genuine administrative action. But once you start getting into the realm of beneficiaries, I suppose, almost fighting with each other as to the extent of their rights, then you're coming out of the administrative suit type action, you're getting more into a contentious application, and then the costs won't necessarily come directly from the estate in that instance. Just a recent decision of the High Court at the beginning of the year in Muckian, that concerned an administrative action whereby they were trying to remove administrator of a will, and she basically hadn't been providing the potential beneficiaries with statements of account and things like that, so they sought to remove her, and she was successfully removed, just basically because she just wasn't up to the task of administering the estate, and she argued that she should be entitled to her costs unless she was being removed by reason of misconduct. And the court disagreed. It said that there isn't, and if you're into this sort of thing, there's an interesting analysis in the judgment of when costs should be awarded. We obviously all begin with the most fundamental rule, which is that costs follow the event. So if you're the successful litigant, you're entitled to your costs, and if you're unsuccessful, you shouldn't. But obviously that in probate matters, there are some other reasoning that can be factored in. But in relation to this particular case, she hadn't been found guilty, we'll say, of misconduct in relation to her role, but she equally wasn't good enough either, and moreover had contested the removal, her removal rather, as an administrator. And how far do you go, I suppose, in contesting something like that? Why would someone contest that? Why wouldn't you, if the other beneficiaries are unhappy with your performance? I just find it always interesting when people aren't doing anything in relation to the administration of the estate, someone takes an action against them, and all of a sudden they're full of beans and energy and willing to fight at every turn, but equally weren't administering the estate. So they perhaps put their passion into administering the estate. But in any event, the distinction was made really between an administrative action like the ones I talked about, in terms of whereby the executors might have a genuine question, and then a lis inter partes, which is really that dispute, that contentious dispute. And the court held that that was really what was at issue here. It was a dispute about the manner in which she was carrying out her function. She wasn't doing it correctly. There was no real administrative question to be asked, and therefore she shouldn't be entitled to her costs. So that is my overview. I hope it's of some help. As I said, if nothing else, I hope you keep my paper in a drawer and someday it helps you out. I just want to take a moment just before we all head off. I hope you've all received a copy. I obviously am involved in STEP, and we are hosting our annual conference on Friday the 19th of May in the Gibson. What the brochure doesn't tell you is that we have negotiated a special rate with the Gibson for the Thursday and Friday night if you do want to come up and make a long weekend of it. On behalf of STEP, I would really like to thank the SLA for allowing us to come here today and to come together and have a seminar together. It's been really beneficial from our perspective. I hope equally it has been for SLA. I just wanted to thank Julie and Joan and also Carl for speaking on our own committee. I wanted to thank Jim Grogan and Lydia McCormick, and thank you all for giving us your Friday afternoon. That's it. Just to remind everybody, if they want extra copies of the notes, they'll be on the SLA website, and thanks all again for coming and supporting the event.